In this latest interview, I had the privilege of introducing one of the top trial lawyers in the country. His name is Mark Lanier. And if you don't know Mark, just know that he has achieved some of the largest verdicts in history. In fact, his verdicts total at this point to over $20 billion. I'm pretty sure it's safe to say that when somebody enters that 3 comma club, they know a thing or two about trial. But in all seriousness, I truly believe that Mark's secret sauce is his ability to combine his passion with his creativity in order to connect with juries all across the country. Mark also connects with fellow plaintiff lawyers through the Lanier Trial Academy, which he hosts every single year in order to help plaintiff lawyers become better advocates. If you're interested in checking that out, I'll provide a link in the description down below. But most importantly, Mark Lanier is also a graduate from Texas Tech University School of Law. So shout out to all my fellow tech law grads out there. Shameless plug. So in this video series, Mark is going to share his insights, techniques, and philosophies. And while I was doing this interview, I couldn't help but nerd out a little bit because it was such great information. If you find yourself agreeing, if you find yourself liking this video, then don't forget to hit the like button down below. Doing so allows videos like this to rank higher so we can reach more people and ultimately help more people. That's always the goal. All of this out of the way, I hope you enjoy this interview with Mark Lanier. All right, everyone, welcome back to another interview on Law Venture, and I have a special guest, Mark Lanier. Mark, thanks for being here today.
I'm delighted to be here, Jared. I hope this is worth your time.
Oh, absolutely. I already know in advance it's going to be. So with these interviews, I like to just dive on in because I know everyone wants to get as much insights and thoughts from Mark Lanier as possible. So are you okay with us just jumping in?
Let's go into the deep end, right off the board.
Okay, so in another podcast interview that I was listening to, you mentioned that there are 4 critical moments in trial. Can you talk about those?
Sure. The first critical moment to me is the first time you stand up to meet the jury, the impression that you make on a conscious but also an unconscious level. A lot of studies have indicated that people in a fraction of a second unconsciously will register things about you, including whether they like you in some regards. Certainly whether or not you seem trustworthy. All of those things happen in a nanosecond, unconsciously, and then consciously we begin to unfold and walk into the ideas that our minds already set. So that's one. A second one is your opening statement, because your opening statement is where you lay out your case, and you need to do so thoroughly. You need to do so with assiduous accuracy. You don't want to gild the lily. You don't want to oversell. If anything, I tend to undersell in opening because you need to be able to live out what you've said. A third critical moment in the trial to me is when you put your main witness on, your plaintiff, because the juries give good verdicts to good people. And so when you've got a plaintiff or a defendant, but you put that witness on, especially the plaintiff, because they go first, that's a critical moment in the trial. And then the fourth critical moment is the very first witness for the defense, because that sets the stage for whether or not the opinions that have shaped over the course of the plaintiff's case seem right to the jurors or perhaps are called into question. If that first defense witness blows up, then the jurors confirm what they already suspected about the plaintiff's case, assuming the plaintiff has made their case. Those are the 4 big ones. Now, there are 2 that are honorable mention. The 2 that are honorable mention are the very first witness the plaintiff puts on the stand and closing argument. The first witness, because that witness can, in a sense, refute the opening statement the defense has just given, because the plaintiff doesn't get to respond beyond calling a witness. And also lays an impression for the rest of the trial of how the plaintiff's case would go in. Honorable mention number 2 is closing. I don't know that closing argument really changes anyone's mind. I think everybody's mind is either made up or isn't going to be made up by some eloquent argument. But what closing argument can do is it can arm your witness, your jurors in a sense, to be your witnesses. It can arm your jurors to go back and argue the case in the jury room during deliberations. That's the main punch of closing argument. So closing argument, I look at not so much as my chance to persuade everyone who hasn't been persuaded by the trial thus far. I look at closing argument as my opportunity to arm my jurors with the ability to go back and win in the jury room, the deliberation process.
Mark, I think you just gave us a roadmap for this conversation here. So I'm going to probably dive a little bit deeper on a few of these. The first one being the first time standing up in front of the jury. Is there an inherent skepticism that potential jurors have with lawyers that we have to overcome? And if so, how do we overcome that?
Well, I think with some, there's
Okay.
an inherent skepticism. I think with some, there's an inherent interest. Not so much a skepticism as a, hey, we watch these shows on TV. This is going to be really cool to see in real life. I wonder what it's going to be like. I think some are too afraid to have either skepticism or interest. They're worried about themselves. Are they smart enough? Are they careful enough? Are they caring enough? Are they, they're in a foreign territory doing foreign deeds, and yet they seem to be very important. And are they up to the task? And some people are so self-consciously worried that they're not skeptics, cynics, or anything else. So I think there's a breadth of reaction among people. But anytime we meet someone, we're making assessments. And there are a lot of criteria that go into determining whether or not someone's credible, whether someone's likable. Those criteria, the scholars have tried to study them and reduce them to writing, and some of them are easily understood. Some of them are hard to define. It's easily understood that people tend to like and be attracted to people of power. Not saying that that's a good thing, just saying that's a factual thing. That's easy to understand and describe. We know what that means. But then there's another factor that winds up being described as people are attracted and like those who are winsome, winsome. Well, what the heck is that? What does it mean to be winsome? That's something that's hard to put your finger on. We know that people like folks who are attractive, but that's an interesting concept, because by attractive, in terms of credibility and trust, they mean not the inordinately supermodel beautiful or GQ cover strong chin male. They mean someone who, in the realm of normalcy, would be on the good looking side of normalcy. And that's a wrapped up in this idea that we like people who are like ourselves. And so if you get to that supermodel level of beauty, very few people feel like they can relate to that. So there's that. But then you still get to the question of, well, what makes someone attractive? Is it symmetry in the face or asymmetry in the face? Is it a smile? There was a study that was done once among men where they showed men 50 pictures of women and said, which women are more attractive? And half of the women had their eyes dilated. And like 75% of the men said that the women with the dilated eyes were more attractive. Then they did the study again, but they dilated the other 25 eyes, not the ones that were originally dilated. And the 75% went to the other women with dilated eyes. So, does dilated eyes make you more attractive? There are lots of factors that go into this. This is not an easy 1, 2, 3 manual type thing. This is a complicated thing. So I do a what I call the Lanier Trial Academy. We'll be
Hmm.
doing the seventh one this summer in June, 7.0.
I'm
And
signed up for that, by the way. I'm looking
hey,
forward to it.
okay, well, you will hear 2.5 hours of me. I mean, 2.5 days of me launching into this stuff, Jarrett, because it's the kind of thing that has so many different levels and layers
Hmm.
to it, and it's interwoven with other aspects of the way the mind works. So it's fascinating. But yeah, there are some that are skeptics and cynics. There are some that are interested, some that are scared, some that are frankly bored. And what the lawyer's got to do in that first moment is try to capture as many of those people as the lawyer can, and she or he needs to be the kind of person that even before a word comes out of their mouth makes a good impression, starts out on a solid footing.
This is really interesting to me. So I want to take it maybe one step further because there are two, I don't want to say extreme, but maybe there are two ends of the spectrum that I've seen taught with jury selection. One being stand up and just start asking questions right away because your time's valuable and you want to be as neutral and as gray as possible. I've seen other lawyers who are great at charming and, charming the pants off of potential jurors, and they come in cracking jokes to help ease the tension. And then obviously there's going to be, philosophies in between. Where do you sit on that?
Well, you clearly have to use your time efficiently.
Mm-hmm.
Um, but the first thing that I do in jury selection is try to put the jury at ease, because I do think that they're nervous. I think that they're curious. I think they're wondering if they're up to the task. So I have a pretty standard line I use at the beginning of voir dire, um, as we call it in Texas, other
Or
states,
voir dire.
like voir dire or
Yeah.
whatever. Um, But so the first line that I use is to put people at ease. The second thing that I do in jury selection is I try to tell them something briefly about the case. A power statement is what I call it. What is this case about in one sentence? And that sets a stage for inquisitive dialogue where you get the people to speak. But yet even that can be done, I hope, in a charming, bonding, relatable sense.
Mm-hmm.
And so, I look at it as headlights on a car. I don't want to pick the left one or the right one. I'd like them both. And, I want to have my cake and I want to eat my cake. I want, I want to do everything possible out of 100 points that you might be able to score in voir dire. I want 100. I don't want 99, 98, 97, even though those are A plus.
Mm-hmm.
Getting the 100, I rarely do, but that's what my target is each time.
I love it. I love it. And then moving to opening statement. From an outsider looking in on some of the trial videos that are out there of you, I feel like you just absolutely thrive in opening statement. I don't know how much time you put towards opening statement compared to everything else, but your ability to simplify the case, which actually I had an interview with Shane Reed. We talked about you specifically and used one of your, I think it's the Johnson and Johnson example of honing in the case down to one sentence. But you also, and this is what I was fascinated by, you also go into the weeds to some extent. And I don't know if that's to establish your own credibility and knowledge, but I'm curious on what your philosophy is with opening statement.
Well, I do like opening statement to be assiduously accurate. That's the phrase that I use. I don't want to round up a number. I don't want to leave out a bad fact. I don't want to pretend the case is something greater than it is. I want the jury to know that from me, they're going to get the same thing that a witness swears to give them. And that is not just the truth, but the whole truth and nothing but the truth. And so my biggest point in opening is to be accurate. My ancillary points, if you will, I want to tell a good story. I want it to be engaging. I want the jury to find it fascinating. And that means speaking in words and terms that people understand. Um, right now my brain is working on getting ready for my next trial academy, which are coming, and one of the little modules that I'm plugging in involves word choice. So, for example, there are studies that indicate using a noun has a different punch than using a verb. And so, as I'm working on my opening statement and trying to word these things, I take word choice into account. I'll give you an example of that briefly here. Um, if I want to say Jarrett uh, is going for a run, I can, Jarrett is running a 5K. I can use that run concept in a verbal sense. Jarrett's running a 5K. Or I can put it into a noun and say that, Jarrett Stone is a runner. Now, the difference between saying Jarrett is running and Jarrett is a runner on an unconscious level is profound. Runner, using that noun, has more permanence to it. It seems more of greater gravitas. I mean, you might be going for a run, you might be running a 5K, it might just be something you're doing on a lark. But if you're a runner, by golly, you're serious about this. It frames the unconscious mind differently to put it into a noun form than a verb form. So Donald Trump's a champion at this. He doesn't say that people lose this or that. He'll call them a loser, and that's got a lot more punch to it than just using the verb that someone lost. And so when I put together opening, I try to pay attention to word choice. There's a difference between saying can't and won't. There's a difference between saying could and would. There's a difference, and those words have different values. I do try hard in opening to find the weaknesses in my case and cast them into the case in a positive fashion. When I was trying the opioid litigation against the pharmacies in Ohio, one of the problems I had with Walgreens is Walgreens put a good faith and dispensing checklist out for their pharmacists 20 years ago that said, if you're going to dispense an opioid, here are the things you should check off before you dispense an opioid. Well, that sounds incredible. But in fact, the checklist was pretty weak. It was kind of watered down. The DEA didn't care too much for it. And over time, the requirements were made more clear. And what Walgreens did is they tightened up a little bit their checklist. And then 3 or 4 years later, they got hit again by some DEA enforcement. They tightened it again. Then they get sued by us and they tighten it again. Well, by the time we get to trial, they've got 4 or 5 tightenings of this. And I have no doubt that an uninformed jury is going to just hear, well, here's our checklist. Look how thorough it is. And not have in front of their brain that that's the 5th edition. And the 4th edition wasn't that good, and the 3rd edition wasn't, and the 2nd edition wasn't, and the 1st edition was pretty deplorable. And witnesses were going to get confused over it, and the opening statement of Walgreens, which I couldn't respond to, was going to confuse those. So I knew that would be a potential trouble spot. So in my opening, I wanted to deal with that. Now, how am I going to deal with that? I need to do it in a way that not only makes sense, that not only brings it down to something comprehensible, but in a way that's memorable. So in my opening statement, I got I think from Amazon, 4 gardening sieves. These are those round things that have screens in the bottom where you can sift out sand or sift out gravel or sift out weeds or sift out, I guess you could use it to pan for gold. But I got 5 of them with different sizes of screens in the bottom. Some very small, some very large. And then I got a big container of flour, a glass container of flour, as in baking flour from wheat. And I got some Red Hots. I got some Nerds, the candy Nerds. I got a number of different kinds of candies that were basically red in color. And then I told the jury, and I got a big glass bowl so the jury would be able to see this. I told the jury that the responsibility of a pharmacy is to let the valid prescriptions through, but catch the bad prescriptions, the fake prescriptions, the dangerous prescriptions. And I said, so flour here is going to be my representative for good prescriptions that need to go through. That's most of them. But these Red Hots and Nerds and the various candies, these are the bad prescriptions that shouldn't go through. So I took them and I put them into the flour. And I said, now, Walgreens had a filter, they had a sieve, they had a good faith dispensing, and I held it up, the one with the big holes. I said, but the holes were way too big to catch anything. This just kind of covered their backside and said, oh yeah, we've got a system. But the system's useless. And I took the flour mixture, I put it in there, and all of the flour and all of the candy, the bad prescriptions, they all fell through into the glass. I said, so the DEA fined them and said, you're not doing this adequately. And they said, okay, we'll tighten our filter. And so they got another filter with the holes just maybe a little bit smaller, but not much. And I held up the second sieve. And I did it again, and it caught a few of the Red Hots, but not many of them, and all the Nerds through. And I did that with each successive filter. Said, finally we brought a lawsuit. Now they've tightened it up. But do not let them, never, never, never in this trial, let them hold up the good faith dispensing that is their 5th sieve and pretend it's the same as the first sieve. Anytime they hold up one of those, look to see how big the holes are. Now, that was a graphic way to illustrate a point that, frankly, could have cost us the whole trial. But the jury grabbed hold of it and rode it all the way through trial. And I think that was a good driver for helping us win that case.
I have a few takeaways with that. And the first one being the runner aspect. When I hear that, I hear identity. Jarrett is a runner. That's an identity that maybe was taken away versus Jarrett was running. That's just an activity. And
well said.
That's powerful. That's powerful. And then maybe to inverse what you're saying about the power of opening statement and accuracy. Correct me if I'm wrong here, but it sounds like you're also holding the defense to the same accuracy level, because I want to say it was the Johnson & Johnson case, I was watching part of the trial, and I think you had one of their demonstratives, one of their PowerPoints, where they said plaintiff isn't going to talk about this and plaintiff isn't going to talk about that. And then you put that up there while you were cross-examining, I believe, one of their experts, and then you said, we did talk about this. We did talk about that. Do you mind, sharing the thought process there?
Yeah, so I try really hard to take advantage of defense openings that are not accurate. And, one of the most graphic examples to me was a case I tried in 1998. It dealt with a company called Carborundum. And I got up and I gave my opening, and the defense lawyer got up and gave an opening that just was flat wrong in so many ways. And so I altered my first witness. Instead of putting on who I expected to put on, I called the company representative adversely and put him on the stand right after opening. And I said, you work for the company, or you're the company rep? And he said, yes. I said, you sat there and listened to your lawyer give the opening just now to this jury? Yes. I said, I counted 17 things he said that were wrong. How many did you get? And he said, what? I said, I counted 17 things he said that were wrong. How many did you count? He said, well, I didn't hear anything wrong. I said, okay, let's go through my 17. And I had a big old tablet. I wrote down the first one. And I put it in quotation marks. I'm getting real time. I've got the record right there. And I said, that's not right, is it? And he said, well, no. I said, in other words, that's a lie. Well, I wouldn't want to call it a lie. I said, well, you want to call it an untruth? And he said, yeah, we'll just say it's an untruth. I said, okay. And then I wrote down the second one. I mean, he agreed. All 17 were false. And at that point, the jury was like never going to believe another word that lawyer said. And that I thought the case might be over at that point, assuming I could prove damages and compensation. So anyway, it is, lawyers must be very careful in opening.
So this is something I struggle with. There are, maybe I'm biased here. There are a lot of times where I feel like the defense lawyer is the one who's making the mistake. And my fear is that a jury's going to almost have sympathy for the defendant in that situation. Let's just say the defendant is a person, not a company. And then trying to spotlight the mistakes that the defense lawyer is making to where it just seems like bad lawyering and maybe poor defendant. Have you run into that?
Yeah, that doesn't bother me. I think
Okay.
that most of the time people relate the two.
Mm,
And you can all, if you've got that one rare circumstance where they may not, you can always cross-examine the defendant
mm-hmm,
in that situation and put them on the hot seat, kind of like I did that corporate representative.
mm-hmm,
You know, do you agree that what the lawyer said was false? No, I think everything he said was accurate. Well, let me go through them. Okay, I admit it. Okay, I admit it. And
mm-hmm.
but if that witness started out, you know, if you put if you cross-examine a witness with a bad lawyer and say, hey, your lawyer's wrong on this, aren't they? If the witness says yes, the jury may feel a little bit bad for the witness, but at least you're going to win.
Yeah.
The jury says no, that witness has just bought all, or the juror says, a witness says no, witness has just bought all of the bad lawyering that's out there.
Yeah.
So that's never bothered me that much.
Okay. Okay. And then talking about plaintiff testimony, do you follow the school of thought where you want to hype up the plaintiff's story as much as possible through other witnesses and keep the plaintiff on the stand for the least amount of time as possible? Or do you try and really shine light on the plaintiff?
Well, there's a lot that you need to do with a plaintiff. And so wouldn't say that I keep them on the stand as little as possible. I keep them on the stand for a right amount. Sometimes that is little. Heavens, I've had some plaintiffs I've just not even let come to the courthouse. Tried a case in Lubbock like that one time. But I do think that a plaintiff talking about their own damages is not as powerful as someone else talking about the plaintiff's damages. So I tried a case one time in San Antonio, and one of the appellate points was that the consortium damages that I had for my wife to the injured fella were the largest consortium damages ever given in Texas. Ergo, it was a runaway jury. And an ex-Chief Justice of the Supreme Court made this argument in a motion for new trial in front of our trial judge. Judge was Tony Arriaga, a woman, great trial judge. And Judge Arriaga said to the ex-Chief Justice, said, you've given me a chart with 50 consortium claims. You've said this is the largest consortium damage ever assessed in Texas, ergo a runaway jury. But what you never did is you never explained to me why this isn't the worst consortium case there ever was in the state of Texas. Because if it was, then it's not a runaway jury. And then she started peppering the ex-chief justice on whether or not he'd read the record. And the consortium case that I made wasn't made by the woman. I made that through the injured spouse. So the injured spouse was someone who had been paralyzed from basically the diaphragm down. And as a result, his wife, he couldn't even use the bathroom. His wife had to digitally evacuate his bowels every other day and would for the rest of his life. And I could put her on the stand to talk about that and talk about how horrible it was and how humiliating it was, and that that's not what she signed up for when she married him. And she'd have done fine with that, and it would have been authentic, real testimony. But instead, I put him on the stand for that. And I said, I want to talk about your wife. I had her leave the courtroom. And I said, I want you to tell the jury what your wife has to do. And he broke down, he started crying. And he says, you know, she has never complained. He says, she knows it embarrasses me, and yet she makes it. She sings to me, she talks to me, she tries so hard to make it like this is just a part of marriage. And I mean, and that whole jury's weeping over what a saint the wife is, knowing. And he said, but I know that this is not what she signed up for. I mean, we say in sickness and in health, but we don't imagine this. And, you know, and then I had her on the stand talking about how her husband tries to protect her, but he knows that there's no protection there, that he sleeps with a baseball bat. And he talks about if someone breaks into the house, how she's got to stay right next to him in bed because he can't defend her unless the guy comes up to the bed, because he can swing the bat, but he can't go after the guy. And I mean, it was profound because each were testifying about the other's damages and saying, hey, I'll be okay. Don't award me money for mine. I'm going to be okay, but take care of my wife. And the wife saying, I'll be okay, but take care of my husband. That's more powerful.
So along those lines, when it comes to motivating a jury and having that powerful feel throughout the trial, when I watch some of the videos online where you're talking about motivation, and you're talking, I think in the Johnson & Johnson case, you were using the term targeted, like targeted these plaintiffs. It's a civil case that feels like a criminal case. I don't know if that's intended or not, but is that the philosophy that you're trying to use?
Yeah. So sometimes you have cases where the jury is not so interested maybe in a product liability case, but they're always going to be a real strong pro-justice case in a crime sense. And so there are times where I cross over and use criminal language. I'll talk about alibis instead of defenses. You know, I voir dired one time where I asked the jury, what would you do if you found someone guilty for killing people for money, basically, you know, like a hitman or something? They said, well, that's, you know, we'd fry him, give him the electric chair. That's capital punishment stuff. I said, well, what about if it's a company that decides that certain number of people are going to die by their product, but they're going to make profit off of it, and in the long run, it's worth letting those people die? I said, what do you do if you find out a company did that on purpose? The guy looked quizzically up in the sky and he said, well, I guess you bankrupt them because you can't put a company in the electric chair. You know, I'm kind of like, okay, he'll do. I'll take him as a juror. People, sometimes it's more compelling to think and to speak in terms of crime. I do liken what I do as a plaintiff's lawyer to being a civil prosecutor.
Mm-hmm.
You can't lock Johnson and Johnson up in jail. All you can do is fine them. And it's
Mm.
rare that a DA is going to go after them because the crime is against the people. In a, could you go after them for assault? Maybe, but not really. That's what our civil court does. But I'm basically a civil DA in
Mhm.
some ways in my mind. So I do tend to look on the guilty as guilty.
Yeah, that's powerful. So, Mark, let's maybe transition a little bit. I'm sure there'll be some overlap into your philosophies overall with your legal career. Is that okay?
Seize it. Don't do it just for the money. Don't do it just for a retirement that's comfortable. Do it because it's the right thing to do, and you're using your heartbeats to make the world a better place. I mean, that may sound schmaltzy, but I think that's what life's about.